Mr. Conroy.
No mental deterioration there, my submission. Chronic user, living, breathing example. I'm going to come back to the Section 7, Section 1 point again. There was lots of discussion about the court being a gatekeeper, and it always seems to be a gatekeeper in terms of the accused or the individual who's affected. And so, again, if you import from Section 1 into Section 7 some of the criteria and so on that you seem to be doing, at least in part, proportionality at least has come into the Section 7 balancing. Now, why can't something happen as happened with Mr. Malmo-Levine, for example? The person isn't just making an allegation that something's unconstitutional. They come forward and they perhaps tell the court what the basis for their unconstitutionality is. But then why wouldn't the court turn to the government in a case where harm is the issue and say, government, well, tell us then what the basis for the harm is? In my submission, in a free society, the starting point surely is that we're all free and we give the government the power to limit our freedoms.
Is this reply?
In my submission, it is generally.
What point are you replying to?
Well, it's the general submission of my friend, not any specific particular point.
Well, I think the court would appreciate your point, restricting yourselves to specific, the autonomy issue has been argued on both sides very thoroughly, and unless something new has been said specifically that you need to respond to, I think
all right.
We can take it as dealt with.
Okay, in that case, I'll just take you very quickly through some of my responses to some of the things Mr. Frankel said. One of the issues is smoking is not the only method of ingestion. Just want to bring that point out. He seemed to focus on tar content being higher and so on and so forth. Dr. Callant's evidence was to the effect that if these marijuana cigarettes are properly manufactured, if people don't take deep lung samples, if they don't smoke it down to the very end, and if they put a filter in, then the harms to health are reduced even more, the black market risks that he addressed. And my friend talked about graduating to harder drugs, and I think it was Madam Justice Arbour who mentioned the contact with dealers. I think there's evidence in the record in terms of the Dutch model, which was precisely to do that, to move the marijuana smokers away from the hard drug dealers. In my submission, if you looked at the number of people who started, who went to progress to heroin or cocaine, and you see that they may have used marijuana before, I'm sure if you asked them if the first drug was maybe going into their parents' liquor cabinet, you would have got the same response, that was where they first started. So in my submission, there's no association in that regard. My friend said the jury's still out in terms of the harms. Well, that's because they won't let the jury come back and make a decision. The government, through its prohibition model, doesn't allow sufficient research and so on to be done in order to come and demonstrate the lack of harm. They control and restrict people from doing sufficient research. My friend says it's been considered by Parliament. I said this in my submission in chief, and I say again, it hasn't been. The approach, my friend said, this is democracy in action, democracy and how democracy works. Well, in my submission, what's happened with marijuana is, again, they've never considered it and had a full debate in Parliament. They have always gone the route of royal commissions or committees of one sort or another, made promises, and then put them on the shelf.
I think we have those submissions from your position in chief. Is there anything further?
I don't think there is, Chief Justice, if I may. Oh, one point on impaired driving. A comment was made about there being no device in terms of impaired driving. Well, the law on impaired driving is if your ability to drive is impaired by alcohol or a drug. You don't need a device for that. It's the .08 charge that's the breathalyzer machine. So what does an officer do when he stops somebody in a vehicle? He observes that person. has the right, according to the cases in the law, to have the person step from the vehicle and perform a number of roadside tests in order to determine if their suspicion about the person's intoxication level is such as to affect their ability to drive, their motor coordination skills. A police officer can do that just as easily with a marijuana smoker.
Suppose the person's had a seizure. Suppose he's had a minor stroke. Out of the car and he can't perform any of those tests. He's been smoking marijuana. There's no odor. There's no way that the investigating officer can tell that he's impaired by a drug.
Well, if
it's odorless.
There's lots of odor, with respect. But how, Judge Major, in many cases that I deal with, the very basis for the officer searching the car is the odor. It's a constant problem.
Well, if you're giving evidence, I'll listen to it. But someone who has smoked a marijuana cigarette, driving a car 10 minutes later, he give off an odor that the police officer would recognize as being a drug of some sort?
He may. In Caine...
He may or he may not.
Well, in Caine, originally the Crown was going to call a policeman who was an expert in this particular area to show what they had been doing and how they'd been training the officers to detect marijuana in drivers. But then they chose not to call that person. Had they called him, we'd have that evidence for you clearly in the record. We cross-examined Dr. Callant about it, and it's my recollection that what I've been telling you came in part from Dr. Callant in terms of, again, this question of how does it affect a person's motor coordination skills? If you're intoxicated, presumably, by having you do various tests, an officer who's trained can determine that. And it's not peculiar to... And if he can't determine it, if it looks like the person is able to walk a straight line and so on, then there's no basis for charging them with impaired driving.
Yes, I haven't made my point. He may not be able to meet the test because of physical disability, not an impairment by use of a drug. Alcohol, it's easy to tell that the person's drinking. Is it easy to tell someone's been smoking marijuana?
From the cases that I've been involved in, it appears certainly there are officers who seem to have no difficulty determining that a person has consumed marijuana. I don't know of any cases that I can tell you of where they found the person to be impaired. Yes.
Yes, Mr. Burstein.
Thank you, Chief Justice. Just very quickly, dealing with the last point, perhaps, Justice Major, that's one of the benefits of some form of decriminalization. Right now, there's a bit of a myth or a fallacy that such a device is not needed because the actual possession of marijuana is criminal, so therefore it's almost presumed that no one is actually smoking and getting behind the wheel, which in my submission, or at least my experience, isn't true. But no one has ever bothered to develop the device. Presumably, they developed the Borkenstein breathalyzer and have progressed since then. The cannabis remains in the system. It simply requires a demand for someone to go out and produce, in my submission, a device that could somehow measure the content in the blood. In any event, I have three discrete points to make. One, Mr. Frankel read out a passage from, I believe it was the judgment in Clay, where Justice Rosenberg refers to a number of possible harms, and I believe it's the one set out in our joint statement of legislative facts on page 3 at the bottom of paragraph 3, where we've highlighted the word possible in terms of the possible precipitation of schizophrenic relapses, possible... Sorry?
I think it was Parker he was reading from.
Yes, it is Parker, sorry, and actually that's referred to, it is the same passage in our factum. The point I make is this, is that in this respect, you have to go back to the Crown's evidence that gave rise to those statements, because, of course, bear in mind the passage came from Parker, but referring to the record in Clay. And if you look at Dr. Callant's evidence, which is in Volume 6 of the Clay appellant's record, specifically pages 1237 to 1271, you'll see that the use of the word possible by Justice Rosenberg can only be read to mean possibility that a causal link exists, not that, in fact, there's a causal link that the harm will possibly arise. In other words, if you look at Dr. Kalan's testimony, he doesn't say that it has been established that there's a 20% possibility that someone who smokes marijuana will suffer from long-term cognitive disorders. Rather, he says the state of the evidence is this might possibly be, there might possibly be such a causal link. So in terms of assessing the significance of those harms, it's important to look at the original record. My second point, the Crown argues that any formulation of the harm principle is bound to open the floodgates to a river of Section 7 challenges to various penal provisions and, if not, criminal offenses. But it is my submission that these are